clients come to us after they've already been terminated, but a good amount of people do reach out to us because they're concerned. They think that they're about to be terminated. They sense retaliation. They sense that something isn't going right. That means that they know something's triggering them, that they need to protect their rights. But they often don't know how to do that. What are some ways that employees in the state of New Jersey can protect their rights in case of they suffer an adverse employment action by their employer?
This is a great question, and it's so important because there's nothing worse than someone coming and looking for help too late after, unfortunately, they've already done damage to their case. They've already written away their rights. The number one thing that I often tell people to do is to blow the whistle and to complain to their employer, to let them know what's happening. They feel they're suffering from discrimination or harassment, or they're not being paid properly, or something bad has happened. So many employment laws require you to put your employer on notice. And not for nothing, that might also solve the problem if you make sure that you put the right people on notice. I often encourage people to make sure you put everything in writing. You want to be able to show that you complained in writing, that this was actually happening to you, and you want to try to preserve those writings as well. So make sure you do it in a way that you're going to be able to keep those writings. That will be your proof. On the more extreme examples, I do often counsel clients that a state like New Jersey is a one-party consent state. You are able to record conversations, and that is permissible. You got to be careful. You don't want to do this in other states. But if you and the person you're talking to are in New Jersey, you can feel comfortable recording the conversation so that way you have a record of what's happening and what's being done to you. And the number one thing to also do is not to sign anything before you talk to an employment attorney. So many people get fired under questionable circumstances, and they're shown a severance agreement with maybe a little bit of money as a severance payment, and they sign it. And then they go and they look for an attorney after, and by then it's too late. If someone is offering you something to sign, you can easily say, I need to have an attorney look at this, and employment attorneys will look at it for you and evaluate what's happening for you and give you the right direction.
That's right. Arbitration agreements are enforceable in the state of New Jersey, and it's something I don't admit often, but a lot of them are well written and up to the legal standard. Once that's signed and you take that check as consideration, there's, in many situations, no way around it. There's no way out of it. You do have the option, you do have the opportunity to meet with an attorney before you sign any documents. Once